Hey folks, I'm Greg McLawsen, the Affidavit of Support lawyer. I've spent the past 10 years representing green card holders in federal lawsuits to enforce the USCIS Form I-864. This morning, I am getting ready for a little discovery conference in one of my federal lawsuits, and I thought this would be a helpful time to talk about the sort of documents and information that get exchanged in one of these lawsuits. Discovery basically just refers to the formal process of exchanging information in a lawsuit. So both parties, the plaintiff who has brought the lawsuit and also the defendant, are both entitled to conduct discovery, both to find information that supports their side of the case and also to look for information that undermines the other party's side of the case. When it comes to the plaintiff, so that's the person who brought the lawsuit, that's who I represent, the green card holder who has been sponsored by the Affidavit of Support, there are basically only two types of information that I need to prove the case. Number one, I need to demonstrate that my client, the plaintiff, has been sponsored by somebody who signed the Affidavit of Support. More specifically, that my client acquired status as a lawful permanent resident based on the Affidavit of Support. This isn't hard. If I didn't have anything else, if all I had was my client's green card, which is the case sometimes, you can tell based on the designation on that green card, usually it's going to be IR1 or CR1 in my cases, how that person got their green card. That designation tells you that this person is an immediate relative or conditional, immediate relative with conditional status. So we can know that this person who was sponsored by their spouse got their green card that way. And if we needed to, we could go to federal court, use an expert witness and say, look, there is no way, it's not legally possible that this individual got their status as an immediate relative unless the Affidavit of Support was signed. Why? Because it's required and has been required since 1997. This person just literally could not have their status unless the Affidavit of Support was signed. The way we actually do it in practice, though, is we typically acquire the person's, it's called the alien file, which sounds weird, alien file from USCIS. This is the definitive file that has everything about the person's immigration history. And in that immigration file, we are going to have a copy of the signed Affidavit of Support. Sometimes it comes back with information blacked out on it, but it has what we need to prove the case that our client had the Affidavit of Support signed and filed in support of their immigration case. So that takes care of the first half of what we need to prove, which is how our client got status as a US resident. The second thing that we are going to be needing to prove is that our client has income that is less than 125% of the federal poverty guideline. Why do we have to show that? Because that goes to the core legal duty owed by a sponsor to the sponsored immigrant. Under the affidavit, the sponsor has to ensure that my client has income at or above 125% of the poverty guideline. That's roughly $1,400 per month. That means that the damages my client can recover in federal litigation are equal to the difference between her actual income and 125% of the poverty guideline. So to prove up our case, we have to show what our client's income is because that goes to the measure of damages. Well, again, this is going to be information that's completely within our control as the plaintiff. We know what our client's income was. First of all, we just prove it up with her tax records using both IRS tax transcript, that's the official record of what was filed on federal income returns, and then also the Social Security statement, again, just repeats what that person filed for their personal income history. And then typically we will also have bank statements and other financial records that shows transparently what our client had in terms of money coming in the door. That's all within our control. So to prove up our case, to prove the plaintiff's case, we can usually, if we need to, go through the litigation process without needing to acquire anything from the defendant. On the other side of the equation, what is the defendant going to want? Well, there are basically, I guess I would think about two primary things that defendants in these cases want to do in the discovery process. Number one is they want to probe the issue, explore the issue of what the plaintiff's income has been. In a whole lot of these cases, my client, the sponsored green card holder, just doesn't have any income. She's been unemployed. Often there's a failed marriage. My client has left the marriage. She might not have any work history, might have English language challenges. So oftentimes when we are getting into gear for the federal lawsuit, excuse me, I'm just going to move my keyboard here. My client just isn't employed. And the defendant oftentimes doesn't believe that. And they don't have to. They are certainly within their right to use the discovery process to explore if my client has hidden income. That's something I hear all the time. Defendants always want to tell the plaintiff that she has hidden income. This is usually just a suspicion. There's no actual reason for this, but they can use the discovery process to explore whether my client has secret money hidden away in an offshore bank account. A lot of times they think that my client is doing gig work for Uber or DoorDash or something like that, or think that my client is selling personal property on eBay to earn money. And that's all fair. It's fair for the defendant to use the discovery process to suss out what the plaintiff's actual income was. One thing I tell all defense attorneys early in these cases is, I get it. You are entitled for sure to explore what my client's income has been. So if we want to just skip wasting a whole bunch of time on discovery, and you want to just tell me what you consider to be evidence of what my client's real income is, I will just give that to you early in the settlement negotiation process, even before a case is filed, so that we can just jump ahead to the process of figuring out what the defendant actually owes. I get it that the defendant is entitled to this information, so they can have it whenever they want to, as far as I'm concerned. The plaintiff is not motivated to hide information that's going to come out later. So that's number one. Defendants want to look at the income that the plaintiff has been earning. That's fair. Number two is different. So the second thing that defendants want to do in these cases, not always, but very often, is they want to massively expand the scope of what the lawsuit is about. And here's specifically what I mean. In my world as plaintiff's counsel in an affidavit of support lawsuit, as I said, there are basically two things at issue. Did my client get her green card through sponsorship? Yep. And then what has her income been? Having proved those things, the defendant is liable, and we know what damages are. The defendants in these cases can't usually argue with either of those two propositions. They know they signed the affidavit of support. They know that they're bound by it. They just don't want to pay. And they ultimately can't, they can poke around at the issue of what the plaintiff's income is, but oftentimes there's not really a question that the person has either had no income or very little income. So, still desperate to try to not have to pay the plaintiff any money, what defendants want to do is assert what are called affirmative defenses. What this means is they say, yeah, I know I signed the affidavit, but because of these other things, I don't want to have to pay money under that contract. So the most typical one is they will allege fraud. They will allege that my client duped them into marriage, that it was never a real marriage, it was only about a green card. That's the most common one. They will try to argue that there was some form of misconduct in the marriage, I refer to these as different versions of the "she never loved me" defense. Basically, they want to raise some question about the legitimacy of the marriage, the legitimacy of the relationship, and assert that that is a reason not to be liable under the affidavit of support. Fortunately, over the past 10 years, we've had federal courts very consistently say that doesn't matter, that Congress, in creating the affidavit of support, disallowed defendants from asserting those affirmative defenses. The most recent prominent case in this area is the Belovich decision out of the Ninth Circuit. There was egregious, very bad misconduct by the green card holder in that case. And the Belovich decision says it doesn't matter. That doesn't go to the enforceability of the affidavit of support. Why does that matter for the discovery process? Well, having asserted those affirmative defenses, the defendant then wants to use the discovery process to relitigate all of these issues that came up in a marriage. So they want to conduct discovery on the person's reason for entering into the marriage, conduct that happened during the marriage, was there a physical altercation, what sort of arguments took place, etc. Because those defenses are categorically disallowed under decisions like Belovich, we can usually, pretty early in the process, get those defenses kicked out of the lawsuit and consequently not have to spend discovery resources going through facts that would support or go against those affirmative defenses. Put differently, there simply is no set of facts that prove those affirmative, or that are relevant in these lawsuits when it comes to those affirmative defenses, because the defenses just can't be raised, period. So, classic example that I use with the defense attorneys all the time: if you had a certified notarized letter from my client written back to somebody in the home country saying, ha ha ha, I duped this guy into marriage, it was only about a green card all along. That doesn't happen in any of these cases. This is just a hypothetical. But even if you had that sort of rock solid evidence, it doesn't matter, because fraud is just categorically irrelevant to the plaintiff's case. And so if even that sort of rock solid evidence is irrelevant, then there's simply no need at all to conduct discovery and depose my client on allegations relating to fraud and other affirmative defense issues, because they just don't matter. So at the end of the day, when all the dust has settled, what most of the discovery is about in these cases is the income being earned and what has been earned by the plaintiff. That's what most of the time is spent on. And that's a pretty closed universe of factual material. I used to work for judges doing something called a judicial clerkship out after law school. And I think about things like construction litigation or tort litigation, when you've got, like, let's say somebody gets into an accident in a rental car parking lot. You have all of this extensive discovery about policies that the rental car company had and what sort of maintenance is done on the parking lot. And they're just there's a huge expansive universe of material that's potentially relevant in one of those cases. And these affidavit of support lawsuits are not at all like that. It's a very narrowly focused factual exploration of what the plaintiff's income has been. And so as my client, that person is going to have to, for sure, pull together some financial records. In some cases, maybe 15% of the cases, my client will later face a deposition, which is basically a formal interview in the litigation process where the defense attorney can ask my client questions about what her income history has been. But this isn't really scary, onerous stuff, right? We're not getting into relitigating and exploring all of the marriage issues, so we don't have to spend a bunch of time in the deposition walking through all of the nastiness of a marriage that went bad. These are not family law cases. It's not a divorce trial. The issue, again, is what my client's income has been. So if my client's a jerk, if the defendant is a jerk, it doesn't matter. We need to just focus exclusively on the income issue. So what this means for plaintiffs, for the folks who are my clients, yeah, there's definitely some footwork involved in preparing these cases when you're working with an attorney. But in the scheme of litigation, it's a pretty light lift, meaning relatively easy, not super document intensive cases. When I start a case with a new client, I send them a list of the financial documents, not necessarily that I need to prove the case, although those are also requested, but also the things that I know, having done a bunch of these cases, the things I know that the defendants are going to request down the line. So right out of the gate, we just get all that material prepared, have it standing by. So when the defense attorney gets around to requesting it, we've just got it ready to go. And that's just not a lot of work. So I would encourage you, if you are a green card holder who's considering bringing one of these cases, don't be scared away from doing it, thinking that it's going to be a really frustrating, challenging process in terms of the discovery and information exchange part of the case. That's really just doesn't turn out to be a big issue in my experience in these cases. Hope that is helpful. If you have any question under the sun about enforcement of the affidavit of support, try to stump me, jump into the comments. I am happy to answer any general question there. If you would like a confidential case assessment of your rights under the affidavit of support, reach out to me on our website. We do free video consultations all across the US. Happy to set one up for you. Everybody, have a good week and take care. If my mouse decides to work, I will end the broadcast. Come on, mouse. Okay, it's time for a new mouse. Take care.